Hello and welcome to this 10-minute talk. This is actually the second of a two-part series looking at the acquisition of professional services firms. The particular focus of today's session is if they want to buy us, should we sell? So that sort of sense that there has been some kind of offer or interest from a potential acquirer in a professional services firm and trying to decide as a firm whether or not to accept that offer, how to deal with that offer, and crucially, how to sort of get that offer, if it's attractive enough, across the line. I'm delighted to be joined by two speakers today, two brilliant speakers. And perhaps could invite them to introduce themselves. I'm going to come to you first, please, Zulon, if you could just introduce yourself to our listeners.
Hello, I'm Zulon Begum. I'm a partner at CM Murray, and I specialise in advising professional firms on mergers and acquisitions and governance and partnership issues.
Fantastic. Thanks so much, Zulon. And turning to you, please, Andy.
Yeah, thank you for having me along today. Hello, Corinne. Hello, Zulon.
Hi.
My name's Andy Poole. I'm legal sector partner at Armstrong Watson. For the last 20 years, I've done nothing but advise lawyers and lastly, specialising in mergers and acquisitions of law firms, which is bang on the subject we're talking about today.
It absolutely is. Thank you so much. And we're delighted to have you along as a guest speaker on this particular podcast. So thank you. So just to set the scene, we've got a professional services firm. They're thinking about selling to a larger acquirer in this particular instance. Obviously, each of these circumstances is going to be completely different, but we're just sort of trying to take a relatively generic view to explore those themes and ideas. Obviously, we often use the terminology of merger in these sort of scenarios, but we're focusing on the sort of the acquisition sort of aspect here, just to sort of narrow it down for a slightly more targeted discussion. So I think, Andy, I might come to you first. Let's imagine that this fictional firm has had an offer from a prospective acquirer. What do firms do with the offer? How do they assess whether it's a good offer? And what sort of things should they focus on in that offer? And what really matters? What should really matter to the firm?
Yeah, I think they should probably take a step back before that, because we're, in terms of assessing what good looks like, we need to understand what the objectives are of those individuals that entered into this process to start with. So way before this point, what we should be doing is sitting down thinking, what are your objectives, both for the business and as you as a group of people? And that then drives what we're looking for. It also drives who we go to approach in terms of potential acquirers, because quite often, in general corporate finance terms, quite often you will mass market businesses for disposal, but it doesn't really work in the legal sector. What you need to do in the legal sector is think which firms will have the right match for us from a cultural perspective, from an ethos, from a shared objectives, from a strategic perspective, from a geographical perspective, from a work types perspective, and making sure we've got that match, because you need to make sure it's not going to work unless you've got that right. So the approach we take is we sit down with the vendors and we start by asking them those questions, and then we pull together a short list, and then we have a look through that short list and make it even shorter. And then we probably only go out to speak to maybe 8 firms that may well be interested. And we do that on a one-to-one basis. We do it in a way to maintain confidentiality, etc. But if you've gone through that process, almost thinking about which firms go on there help you to be aligned with the objectives. So if I give you an example of one that we're working on at the moment, the types of acquirers we've gone to approach actually are driven by their objectives, which is making sure they are looking after their staff, their next level. They've got quite a few salaried partners that are really, really good people. They don't want to take over the equity ownership, but they want to retain them. And they want to make sure they're doing the right things by them. They also want to make sure they're doing the right things by their client base. And actually, in those situations, they're not driven by the financial aspects, in which case that then drives who we go to approach in a way that makes sense against those objectives. So if you then start to get offers coming through, we need to be judging against those objectives, not just on a financial perspective, but from a cultural and an alignment perspective. So we need to be thinking which of those firms will look after those people in the best way, which will look after our clients, which will be able to provide the right services for our clients, which ones will be less of a shock to our client base, etc. So as much as it's picking the right buyer as it is accepting an offer or not. Once you've gone through that process, if it is more about the money and it's about the actual value, then obviously that will come into it, and we will probably have done some kind of estimations. We've talked in the previous 10-minute talk in terms of what those multiple ranges might be, and we've got some benchmarks to be able to go back against to be able to see whether it's right or wrong, and we'll be able to help to advise our clients whether that's the right level of offer or whether it's not.
And obviously, Zulon, all of the partners are going to have an opinion on potential offers and potential buyers, and it's a challenging process to manage in terms of getting a decision made. I guess I'm really interested in terms of who do you think the sort of the offer, if you like, should be shared with internally? What sort of decision-making processes sit around those offers, those potential acquisitions? And how do you sort of manage the balance of confidentiality around the process and negotiations versus educating and bringing the partner body along with you in a scenario like this?
Well, to an extent, kind of depends on your kind of advanced kind of planning around this. So you may have already planned way in advance, as we discussed in the last 10-minute talk. And you may already have a working group perhaps looking at a strategic transaction, who would probably be the appropriate group of people to be looking at any offer. But conversely, you may not have planned for this at all. It may be an offer that comes out of the blue. And again, you can still plan for that in your partnership agreement by giving your board some kind of authority to deal with those kind of offers that come through. If you don't, then it's potentially that the practical way to deal with it is really to kind of at the board level or senior management level to assess that offer, probably with some independent advice to weigh up the pros and cons, and how they meet the strategic objectives that you have for the business. And then if the board don't think it's the appropriate one to go for, there's still an element of kind of a duty to inform partners that you've had an offer like this, but a clear position from the board as to why you don't think it's appropriate. So you may want to inform partners at that point. If it is an offer that you think is a runner, when you tell your partners really kind of comes down to at what point you think the likelihood of it going forward is much greater than it not going forward. So in those kind of situations at the board level, you might want to kind of progress talks with the buyer to the point you think you're pretty much on board. You're pretty much agreed on the most kind of high level commercial points. And at that point, it might be the right time to go to the partners. But, law firms and other professional services firms do tend to be quite leaky businesses. So you need to be very mindful around maintaining confidentiality, because if the potential transaction gets leaked, and it often does, then obviously that makes life a little bit harder when negotiating mergers in the full glare of publicity. It's not the ideal situation to be in. So leaving the disclosure to partners to the last possible minute as possible is probably the best way forward. But balancing that against the need to actually have a proper consultation with partners as well.
And Andy, can you negotiate these offers if you've got sort of an interested acquirer and you're, as you say, you feel like there's a good fit, perhaps culturally it aligns with your strategic objectives as a business, and you think it'll work for your people and your clients? Can you still go back to this sort of potential acquirer and negotiate terms, or is that risking them walking away?
Again, to use that word, it's always a balance. But yes, you can go back to negotiate in the vast majority of cases, as long as you do it in the right way. I'm reminded, actually, as you speak, by an example that happened not too long ago, where there was a repeat acquirer that we sold a few law firms into, who was in a meeting with me with my client that was selling into them, or potentially selling into them. And he described what would happen next. And he said, we'll go away, we'll have a look at certain information, we'll give you some an offer. No doubt Andy will negotiate us up on that offer, because that's what he does. And then we'll have a look through the details, and then we'll come back and we'll agree the position. And that just showed as an example, I guess, a reputation that you do things in the right way. You could, on the flip side, say, well, maybe in lieu of that, they'll always put an offer in lower, knowing that it will get negotiated up. But I'd like to think it's more reflective on us doing our job properly. But ultimately, that negotiation comes down to who's got the power. You know, if the vendor is more driven by the fact that there's only one buyer and they need a sale, there's very little you can do. If there are a few people that are interested, without going through an auction, because I don't think that works in the legal sector, but knowing that there are a few interested parties helps from a vendor perspective, but also knowing what's in it for the buyer. You know, what does the buyer want this business for, and what can they do with the business that will make a success for them? Sometimes, actually, rather than valuing based on the EBITDA historically of the vendor, you can see, well, what are the synergies? What are the upside? What will you make out of it? What can we be able to do to be able to push that value up a little bit? So there are conversations that you can have that will be able to up the offer a little bit. Sometimes the buyer will think, well, that might be the case, but you're promising me something that might happen in the future, but I'm not altogether convinced that that will happen. In which case, why don't we protect each other, and why don't we have more of a contingent earnout, for example? So you might be able to put more of the value into a contingency that if it does work well for everybody, then everybody benefits.
So let's imagine that this fictional firm has received an interesting offer. Andy and Zulon have got on the case, and now the offer has been significantly increased as a result of polite but firm negotiation on their part, and the offer has been improved, and the firm is inclined to accept and are going to go ahead, and due diligence and everything all works out. Zulon, I'm really interested in this question of how proceeds of a sale are actually shared between partners. Obviously, there are mechanisms in place to share profits sort of annually in terms of the income profits, but there are often multi-generations of partners. There are some partners who are, say, nearing retirement and might not want to join the new firm post-acquisition, whereas there might be some who've got a good sort of 25, 30 years left on the clock career-wise. And of course, Andy already talked about sort of earn-out or sort of contingent compensation, which muddies the water again. How, in practice, can firms manage that? And what should they be doing to prepare for those? Because surely this is a recipe for people to fall out.
I guess if you're a company with shareholders, then it's a bit simpler. You might have already thought about this. And any kind of proceeds of the sale will go to the shareholders according to the number of shares they hold. But with LLPs, it's very different. And often LLPs will have very complicated provisions around how they divide profits, but they don't distinguish between revenue and capital profits. That's quite common. And again, it goes to the point we made earlier about advanced planning and thinking about this way ahead of actually money being on the table, because once the money's on the table, things can get quite acrimonious between sometimes partners as to how that money is going to be shared. If you think about it way ahead of any money being on the table, then it's a much more easier conversation to have. So looking at your partnership deed and distinguishing between the revenue and capital profits is really important, because often revenue profits, the basis of dividing profits on a revenue basis may not be sensible if you have a pot of capital profits to share. Often revenue profits consist of various elements, so fixed shares, an element of lockstep, an element of performance. And that's hard to kind of transpose onto a pot of money that comes in from transaction. So if you don't have those provisions at the moment, do think about it now before any potential transaction. But if a transaction is on the horizon and you have an offer and you don't have those provisions in your agreement, basically the default provision will normally be the same basis as you divide revenue profits. And as I've said, that may not be appropriate. Unless you manage to agree something otherwise between the partners. So that becomes a question of actually those kind of discussions around the table between partners and coming to a sensible resolution if you can.
Thank you. And apologies, this isn't something I warned you I was going to ask, but when we're thinking about former partners, do you think it is useful for former partners who might have left quite recently to have some kind of anti-embarrassment provision where they get to share in the proceeds? Or do you think that pushes the balance too far, and maybe a former founder or someone, or do you think that pushes the balance too far in favour of people who don't have any involvement with the business at the point at which the acquisition happens?
I'm seeing anti-embarrassment provisions going in more than they used to, and I think it's partly driven by the fact that there has been a lot of acquisition activity and money changing hands in the legal sector since the Legal Services Act came into force just over 12 years ago now. So whereas, money changing hands wasn't a thing back then, it is now. So partners who, especially founders and senior partners who may have devoted decades of their life building up a business and approaching retirement, while they can't find a suitable buyer just before they retire so they can pocket the money and go off to the Caribbean, they do think that there may be a possibility perhaps in the next 5 years or 10 years after their retirement. And they feel like it's only fair that they should have a share of those proceeds. So in those circumstances, they may put in anti-embarrassment provisions, but again, you need to be very careful about how you draft those provisions in and how they affect kind of the tax position of the partners. If it came to, if it did become activated, how the tax would work, and that it's not disadvantageous for the continuing partners to agree to pay a former partner a share of those proceeds once they've retired.
Thank you, Zulon. Let's not get into tax. That's a talk in its own right. But obviously, do take tax advice if you are considering a transaction of this nature. Just before we sign off, can I invite a top tip from each of you? Andy, may I come to you first?
Yeah, my top tip is use advisors properly. Many occasions I've been involved, particularly in professional services, where lawyers are used to representing others. They are used to leading on transactions themselves, and they feel as though they might be able to self-represent. They feel as though they might be able to negotiate. They feel as though they might be able to interact with the other party. And actually, the danger in doing that is in shutting out your advisor. Your advisor isn't fully aware of all of the conversations and may well have their hands tied by their own client, and therefore use your advisor. If you are a lawyer yourselves, make sure you appoint another specialist firm of lawyers, such as CM Murray. Use a specialist, advisors such as Armstrong Watson from an accountancy, corporate finance, and tax perspective. But make sure you use them properly. Otherwise, you may not get the result that you should.
Thank you, and thank you for the plug. Very kind, Zulon.
You've kind of taken my top tip there, Andy. Very good advice there. But I would probably go back to the point around, have probably made in my previous one as well, around advanced planning, around, making sure you have the right provisions in your partnership deed, around giving your board or your senior partners the authority to negotiate any kind of transaction on behalf of the firm. As well as looking at things like, how do you divide the proceeds if they, the capital proceeds if they do come in, giving a much more advanced thought around that, so that you don't get into sticky conversations at the time of any transaction, and which can make the whole process even more difficult than it is.
Well, thank you both very much. That was really, really interesting. Obviously, we can't hope to cover a topic like this and do it full justice in a short period of time, but I hope that's given you a flavour of some of the issues and considerations to keep in mind when embarking on this sort of process. Please feel free to listen into the first of this two-part series, or indeed to reach out to any of the speakers if you want to discuss this further. Once again, thank you, Andy, thank you, Zulon, and thank you for joining us.